we will say today is May 15th, 2024. It's a beautiful, beautiful time of the year in most areas of the Northern Hemisphere. Southern Hemisphere, I guess it's a bit of a fall or autumn area. And thank you for joining us. So we'll get started here. We have House of Freedom International Natural Law Trust topic today with more advanced and different information. Randall Hillner will be joining us and sharing. So again, thank you for joining us. And we're going to let me see if I can find Randall here. Well, not here yet, but he's in Hawaii, so he has a little time to join, I guess. Anyway, we're a project of Verite, means the truth in French. Liberty Debt Elimination System works in the United States, and people who would like to make it work in other countries are welcome to explore the possibility of finding the equivalent laws, because you know the banking scam is pretty much worldwide. We are members of the Worldwide Charter for Fair International Commerce, so look at the principles there that we follow and comply with, and we have our certificate. So if you would like to look at that part of the website, if you haven't already, you may find it interesting. Today's May 15th. Our next trust webinar, or Zoominar, we call it, will be July 17th, a couple of months from now. You're always welcome to look at the playbacks at www.brilliance-videos.com. And we have a phone number at the United States +1 country code at 360-200-7521. My name is Tonson Fairmount. I'm the founder and consultant. Here's a little bit of a bio there. Speaker, radio shows, author, and so on. Randall Hillner is our main speaker, who is the founder of our trust department, the creator of the House of Freedom International Natural Law Trust. He was founder of White Light Unlimited, trustee of One People's Public Trust, and has been innovating every year, has been increasingly improving and polishing the Natural Law Trust and expanding on it. Working with him is his protege, Dominique Hackett, who has given assistance to many clients and has created the Trust Study Group videos that are accessible to clients. Laurel White is working on many aspects assisting with natural law trust, including the study of land patents, allodial title, and private membership associations. So today's topic, private public trading, well, actually our recap of the last one. Recap would be a little brief review of last month. Laurel, I'm going to ask you to unmute and have you tell me if Randall is there, if he's logging on. Do you know?
Can you hear me?
Yes.
Can you see me?
Yes.
Yay. Okay, two good things. Yes, I just went in to check. He was on the wrong link. So let me continue with that. So he's looking for the newsletter link that you send out to make it simple for him.
I emailed it to him yesterday.
I know he said it probably got lost or trashed.
Okay.
Is it easy for you to send another link real quick? And then I'll go put him on.
You want? Does he want it by email or phone?
Email.
Okay. Will
Proton or Gmail?
Well, we usually in Proton is usually how we do it. Hold on. I muted the audience, but I didn't mean to mute you, so I'm going to ask you to unmute again.
No worries. I'm going to go get him on that link.
Okay. So everyone, as you can see, if you were watching the screen, last Zoominar
Sending it.
was a couple of months ago.
Is it on my end?
We had the discussion between private and public, and the difference between trading and commerce. Also, the difference between the benefits of a trust and the benefits of corporations. So if you were there last time 2 months ago, you already know. For those who are new, there is a long list of benefits that the Natural Law Trust has, even over all other trusts, but also, of course, in particular, the distinction between corporate or statutory entities, LLCs, IBCs, international business corporations, domestic corporations, even nonprofit corporations that are statutory, and statutory trusts. So we have chosen the non-statutory pathway. Why? Because you have the kingpins, the super rich, the elite, who created the statutory world to benefit the few at the expense of the many. And they created entities such as the non-statutory trust for their own use, but kept it from the public and didn't have their law schools teach it to attorneys because they didn't want to subject themselves to the same rules that they subject their slave population to. A non-statutory trust doesn't comply with or subject itself to the regulations legislated by parliaments, congresses, and legislatures. Therefore, there is no geographic jurisdiction for the Natural Law Trust. There is only the universal right of contract, honored by all countries, honored by the Uniform Commercial Code, honored by Supreme Court cases, and of course is consistent with universal law, natural law. Laurel, I'll ask you to unmute again because there was some noise. What's the word? Well, here he is. Okay. So, Randall, I'm going to make you co-host, ask you to unmute, and say hi to us.
Oh, thank you.
There he is.
I apologize. I got trapped in the spectrum went down today, and so I left. I didn't have any phone or web service, so I'm happy to be back. And you did an incredible introduction because that whole seminar from last month was such a prime example of what we want to take and what we want to create with the Natural Law Trust. And you did a great introduction. And so we had last month, and now we had your introduction, and we're going to carry on. Did you finish all of this slide? I didn't want to interrupt if you haven't.
No, actually, we're waiting for you to elaborate on the recap.
Okay, perfect. So I was thinking of this morning again. This whole thing about commerce and trading. We talked about it last session. And the idea is that if you're in the private, then you're basically trading a commodity. If you're in the public, my understanding and my experience is that then you're entering into commerce. And so you might need to have entities that work or interface with the commerce with the public. And the thing about the NLT is that it can do both. It can be an interface with the public. It can house a business. It can have a billboard on the front of its storefront. And yet the assets can be hidden away from the storefront in what I call would be a back office, in which case we have a second trust or a second part of the trust so that we can take our assets and separate them. We have an asset to deal with the public, whatever that might be. Excuse me, whatever that business might be. It might be a physical business, it might be a web business, etc. And then you have your back office. This is where you're going to house and store and assign your assets so that they are protected by the trust. So that's how it all goes. And what happens is when you're dealing with commerce or trading, when you're trading person to person, think about it. We're trading, we shake the person's hand in front of us, and that's our trade. Our word is our bond. When we get into commerce, then we need to have written contracts because of many, many reasons. We won't deal with that at the moment. But the idea is that, especially in the US and pretty much the Western world, is it honors the unalienable right to contract. So you have a right to contract. The NLT, the Natural Law Trust, is a contract, and it's not statutory because you're just signing a contract. You're not engaging in a commercial endeavor at this point. So just want to make sure that you understand that up front, the trust that you get from BIC and the Natural Law Trust, you can use either way. You can use it to have a business. You can use it to store assets. You can use it to do both. You can easily do both. And sometimes you might want to have another entity, and that other entity can be an LLC, depending on where you live in the world, or an entity that is justifiable within that commercial structure of where you live. Or you can have a secondary NLT trust. And so one of the trust, basically your storefront trust that houses your business or whatever the vision is of your what you want for your estate or the legacy for your family. It's like Rockefellers and the Kennedys, etc. And then you have that protection. So the idea is benefit comes when we separate the assets. We have a business, we keep it separate from our home and our other assets that may be valuable. And if we go down this list here, we see that we're talking about equity compels performance. So if you make a contract, now here's a really neat thing about the NLT is if we have an unalienable right to contract, and we know that equity compels performance, and that's another seminar that we'll do again because it was very, 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 very compelling before. So we need to have an ability to compel performance, and that is what the trust can do because the trustees can go to any court and make the court compel the trustees to perform on the contract. So it's really a great system. And of course, it comes way back. We talked about early on how it came from English law. Now we're going back and we're beginning to see that early Roman law, Roman civil law, actually had a trust document as well. And we see that the elite or the wealthy Roman society had an ability to create and separate their assets in the form of a trust or however they did it. But the idea was that there was a specific entity that could do that. And so we've gone from Roman law all the way. I'm sure that even 5,000 years ago, particular tribes or cultures had systems of contract. If you shook your partner's hand, that was your contract. And then we get down to, okay, so how does this work, creating a separation of church and state? So the idea is that in order to keep the church and state separate, we needed to have entities. And one of those entities is the Natural Law Trust. And I don't want to go into that today. I just want to say that a separation of church and state is a vital seminar, and we could do all 2 hours on that, I'm sure. And then we get down to the Vatican Bank and Rothschild Bank, and I had a beautiful, well, it was a long monologue on the Rothschild Bank And this person thought it was depressing. And I just went, well, it's just the reality of how it works. A particular genius, a savant comes along, he creates a paradigm that works. We saw it happen with the Vatican Bank. The Pope wanted to control all of his church, and he didn't want the King of England to come in and tell him how to run his church. So he created his own banking system, his own money. Same with the Rothschild. Rothschild came in. He said, I'll tell you what, I have a whole bunch of gold here, and I'll print all the money you want as long as you let me have a contract. And there it was. So Rothschild Bank, out comes the Federal Reserve Bank, the US government, all corporations, all are fictions. That's what we have to remember. Are you dealing with a fiction, which is the corporate structure, or are you dealing with the human process, which is a natural law trust? So there's a good intro. Can we go to another slide? Do you think we can handle it?
Yep. Go to today's
Right.
topic.
Today's topic. Oh, yes. I forgot about today. I thought it was tomorrow already. Oh, units of beneficial interest, UBIs and TCUs. Okay, this has been a paradigm that we've been working on for a while. And our original trust, or the natural law trust that we have in place, does allow for the process that we're now including as another aspect to what we have already in the trust. So it takes it out another couple of pages. And what we've done is we've created a way, it's been done before, it's been done all along, and we can do it with our original trust document, but now we have a definitive aspect, a clause. Whose clause are in this clause? So the clauses help us define what we want to do with these units of beneficial interest and the trust capital units. And so it can be, what happens is when we have a TCU and a UBI, is that somebody comes along, let's see, that might be the next slide. So let's skip that. Let's just go into clauses. So the common law versus equity law is a perfect way to go from one slide to the next. So clauses, who's closing? What are we clausing? Okay. So the clauses, it's just a paradigm on words. Tanzen is such an eloquent writer that I have to strain myself to be able to match his eloquence sometimes in writing. So clausing and closing is a natural element for Tanzen, and it's something that I have to work with. But it's a perfect fit because what we've done is we've drawn out the ability for the trust document to pay for any investor that wants to come in and be involved with the vision that you might have. Let's say that it's your trust and you have a friend who's a really good entrepreneur. He's looking for a venue or a vehicle in order to maybe create a business. And you say, hey, look, I have this incredible trust. It's a natural law trust. And we can take your investment portfolio and we can create a paradigm and use the trust to make that work. And we'll give you so-called, it's like shares, but it's a unit of interest that allows you to be able to capitalize on the work that you've done and allow for the trust to pay for your endeavor. And so the person that brings in the money and the idea would be given TCUs, or trust capital units. The person that is a long-term beneficial interest may be the children of the grantor of this trust. He has his children as the beneficiaries. He brings a gentleman in and gives them TCUs because of a business that's going to make money for the gentleman and for the trust. And ultimately, the trust will allow that to go to the beneficiaries. So what we're doing is we're expanding the trust to have a few more clauses, which allows for a more efficient closing. Next slide, please. So here it is. I kind of said it before, but the units of beneficial interest show how much a beneficiary would be receiving. So the beneficiary would maybe be different from a capital unit person that's going to get it, but the beneficiary is basically is what the grantor of the trust, he wants the beneficiaries to receive the estate on his demise without it having to go to probate, without any kind of stopgap measures whatsoever. So in other words, we set it up so that the units of beneficialists go immediately via the trustees from the trust to the beneficiaries. It's whether the grantor is available to do that or not, or is still alive, because the grantor may pass on before the beneficiaries do, and the trustees have an estate to participate in and make sure that is kept up to date and is equitable for all those involved. Equity demands performance. So what the beneficiaries get to do is that they can demand that the trustees do what the trust says. That's basically the only power they have. And the trustees, since you want to make everybody happy, you're going to either distribute or not distribute within reason to the beneficiary so that they feel they've been taken care of. The units of beneficial interest can go to the beneficiaries for any reason. In other words, it may be a health reason, and so one beneficiary can receive more than the other. In other words, the trustees have a discretion to pay more to one beneficiary than to another, just to take care of the needs. Maybe one of the beneficiaries is getting ready to go off to college, and so the trustees can pay for tuition, books, etc. Whatever needs to be taken care of. That's the difference between the units of beneficial interest and the trust capital units, what you use for the business. Okay, so questions, hold on to the end. And next slide, please. So again, this is that second source of income, and this basically goes to an investor. An investor has a way he wants to present to you, the grantor, and or maybe the trustee, and he has a plan and he wants to show it to you, and he wants the trust to be the vehicle in which he does it, and he's got the source of funds. So it's basically you're going to cut a contract. You as trustee will cut a contract with the person that's going to be funding. I'm working on a program, a process right now where the funder is coming in with the funds, and he's going to be he's going to be the third trustee, myself and an associate, and the funder will be three trustees. And so that the funder will also be able to have a say in how the process goes. I think it's going to work really well. And it's just another source for any of you out there that may have entrepreneurs friends that need a vehicle, and right now you can support that with the vehicle that you might have. Okay, next slide, please. So here we are. We're just taking this contract out a little bit further, and you're sitting with your client and our funder. He has a significant funding source. You have a great plan sitting in your portfolio there. She says, I like the deal. How can we compensate? And basically it's not long-term beneficial interest, but short-term capital unit interest for actually could be a longer term process if let's say you have a 20-year contract, could be longer, and it could be renewable. So it could be, let's say, a 7-Eleven goes on and on and on because it's a renewable contract. And that's what you can do with TCUs. And you can also, as time goes along, you have to remember that the beneficiaries will change. Everybody in this program will change. The trustees will change over time, beneficiaries will change, the grantor will pass on, et cetera, et cetera. So remember that the reason that we have the flexibility and the stability in the beginning is we have a foundation, solid 15-page foundation. That's static. That's the foundation. That's not going to go anywhere. The rest is all malleable and it can be changed. That's changed through amendments and minutes, et cetera. And that's done with the work of the trustees and or any third-party contractor that wants to come in and contract with the trust. Could be anything, anything. So that's TCU and UBIs. Next slide, please. Clauses, what do they do? Okay, so here we go. So I think at some point, maybe we're going to have to break out our trust document for those that might not have it and just give a lot of the headings. So, but what the headings do is that we have like, I think there's maybe 24 to 26 different headings. And what it is that's like a clause. And in that clause or heading, is it going to tell you exactly what's available for whatever process is within that particular aspect of a segment of that document? So we might have a clause that talks about the power of the trustees. And we might have a clause that also has a responsibility of the trustees, which are pretty different from the powers. So as long as that definitiveness is there, then we're on that safe side. So wherever we need something to be as defined as clearly as possible, that's what we're doing with these different clauses. So they're not meant to confuse, they're meant to clarify and bring about more understanding with the trust document. Next slide, please. Okay, we talked about this. Basically, you have an entrepreneur and a funder. One gentleman has the funds, another gentleman has the contract, and exchanges are made. Basically, either a contract, and now we're going to introduce the ability to have trust contact units, trust credit units. So here we go. Another slide, please. The need for natural principles and justice. Okay, so here we're getting, this is what was interesting here in the last couple of days ago, is that I needed a couple of things to finish. And what I did is I went back into some of the latest law books I have, and I found these quotes. And one of the quotes was from one of the chancellors in the English law. He said, what happens is, not available in common law, which did not recognize the claimant rights. In other words, the common law said, okay, there's been a foul, but they weren't available to say, okay, and we need to give you compensation. We need to give compensation to the person that you fouled. So the common law didn't do that. So what the equity did, and the natural law trust does, is it's come in and it's presupposed the existence of the common law and modified it to support it with a lot more equity. So equity is based on conscious and natural justice. So here, I mean, this is what Brilliance in Commerce is all about. What we've been doing for 20 years is we want to work on the level of consciousness and freedom. So you don't have the level of consciousness and freedom unless you're willing to expand into the principles of natural justice and natural law. So that's what we've done with the common law. And it's great. It's stepped it up from just recognizing a wrong into saying, okay, now we have an equitable compensation for that. And the courts all fine, and the trustees fine for the fact that if there's a foul, that the trust must pay. If there's a foul, the trust must sue to get equitable compensation. So that's it based on your conscience. Next slide, please. Again, second paragraph. In common law, the claimant was offered rewards for damages, but not necessarily much of what he wanted. In other words, let's say somebody came and spoiled the side of his barn with some paint. And the court came in and said, well, we'll give you the paint. But the farmer still had to go out and find and get somebody to paint it. So, but with equity, the court would say, okay, we're going to make this gentleman who painted your wall, we're going to make him buy the paint and we're going to make him paint the wall. And if he doesn't show up, we're going to subpoena him. And if he doesn't show up for that, we'll put him in jail. As Mr. Friday would say, just the facts, ma'am. So how did that happen? Okay, so they bring in a court, either personally, or they bring in a court over a thing. If you didn't follow your contract, then that contract or thing can be presented to the court. And if you're a trustee, then you either have to present yourself as trustee or you have to disappear. So again, if you disappear and you're in contempt of court, you do not want to tell a lie, as we see in the political scene of today. Okay, another slide, maybe. Lord Shelburne, look at that estate. Townsend, didn't you say that you were living up on the 4th floor here on this estate? I think I remember. I can see you waving out here. The courts in England are, and always have been, courts of conscience, operating in personam and not in rem. I'm working as a human being and not as a thing. And in the exercise of this personal jurisdiction, they have always been accustomed to compel the performance of the contracts and trust as to subjects which were not within their jurisdiction. In other words, even though common law was not in their jurisdiction, they took it a step further and demanded that equity be performed. And so they took it to the next step. And that's how we get equity serving justice. Okay, Lord Shelburne, this is Lord Randall signing off. I'm done. You
Ready
have
for
questions? I think that's it.
Yep.
I'm ready.
Well, we have quite a few here, so let's get started.
Let's roll.
My question is why, this is Luke asking, why are the Cook's Island and Nevis trusts so popular compared to the Natural Law Trust? Does the Natural Law Trust have more protection for assets than these other ones?
Yes, Luke, you have my emails on that. I won't go into it in detail, but yes, you're right. Those jurisdictions offer things that you don't get here. However, what we explained is that those jurisdictions, even though they might be free, differently free, they're still a statutory process offered by that regime. So if that regime changes, not that it wants to, but we saw it happen in the Bahamas, then we wouldn't want to go there. Whereas here in the US with the Natural Law Trust, you don't have to worry about that. You don't have to worry about the jurisdiction changes because the Natural Law Trust is a contract between two free people and it has nothing to do with statutory process. Okay.
Yeah, the reason that so many more people do those trusts is they get more publicity by the statutory world. They just don't know about what we have.
Right. Right. And they don't know about us because people in the Caribbean, everybody is, anyway, that's a third party thing. That's all for those people in the public that don't understand what consciousness and justice are all about. We'll just leave it there.
Well, he does say, thank you, Randall. I appreciate you answering my emails. I am just trying to digest all this amazing info.
You're welcome. He can respond accordingly. If he needs more questions, I'm available.
He says, who will be coaching me after I purchase?
What do you want? Belichick's not available. Uh, whoever coaches, whoever, me and Laurel are the one that coach people along the way. Laurel is becoming a very dynamic trustee, facilitator, and I'm there. And so you got the two of us, you got Tanzan and Peter. We can cover your questions, no problem. We have all these people in the background. They're all on the table. They're just waiting to wake up and answer questions. Okay, next.
There's your answer, Luke and everybody. As usually it's Randall, but he has these other associates and a rich network of people around the world to draw on if ever needed. Yeah.
Yep.
He says, I also take it that if you have a natural law trust, nobody or creditors can even find you or know you are a trustee of a natural law trust.
Well, that depends. That's a long drawn out question that I'd rather respond to on an email.
May I just add that it doesn't really matter whether they know you're the trustee or not,
Right. Right.
because even if they do learn you're a trustee, you're still, the asset is still protected if the liability is against your personal name.
Right. Well, if you have it in trust, the only reason that people would know about it is if you tell people. Otherwise, nobody knows who and what is going on with the trust unless the trustees are not obligated to their fiduciary responsibility. If they are, then there's never an issue with it. And you have to allow your name to go out there to get an EIN number in order to facilitate the opening of a bank account. So there are certain elements that some people will know about it, but it's not going to be into the general public. Don't worry.
Right. And I think everyone should know that the protection of your assets does not depend on secrecy.
Right.
You know,
Right.
even if they find out you're a trustee and these assets are there, they still can't touch it. They have no access to it. Even a court judgment cannot attach.
That's right. The trustees can actually they can say no to a judge. They can say, well, I'm sorry, judge, I accept your offer and we need to talk as trustees and we'll get back to you. So there's a lot of strength in the element of a trust and the trustees.
That's the strength of an irrevocable trust.
Yeah, correct. Natural law trust.
Okay, saying what would be the best natural law trust strategy if you have a personal brokerage account that you want to trade stocks for growth and you want to put it in the name of the trust and not your name, but you want to have control to trade the account in the name of the trust? I guess I would need to be the trustee, correct?
Yeah, piece of cake. You're going to be the trustee. You're going to go to a brokerage house and you're going to open an account. Laurel has just had experience with that, tons, and I think you just had experience with that. And so it's just a matter of walking in with the right documents and you as a trustee being able to say, I want to have a trading account with your house.
Right. Yeah, I have an account with a stock brokerage in the name of a natural law trust. And if I want to buy stocks, I just do it as if I were in a corporate name or a personal
Sure.
name, just doing it in the name of the trust.
Yep.
Luke is saying, if you create the natural law trust in the USA, is there any strategic strategy? There's a moron for you. A strategic strategy of what state to have a virtual address for the trust in, or it does not matter. If you live in Florida, can you have the trust virtual address in any state or city?
I've been studying architecture, and there's a piece called stereotomic architecture, and it's this abstract process. And what you just stated was this was looking into the stereotomic galaxy. It's like, see all of this stuff you have on the screen right now? This is a beautiful example. If we're looking into the stereotomic galaxy where nothing is defined, but there's some semblance of reality there. And
Yeah,
that's what we get. And so we just have to define what we are as a being. Who are you? And what do you want to do? And how can we use the trust to make that happen?
that's a beautiful philosophical perspective. And the practical application of that is yes, you can have the address for the trust anywhere in the world, anywhere you want it.
Sure,
It does not
absolutely.
subject the trust to that jurisdiction. It's just for mailing purposes. That's all.
Yes, in care of the mail stop. You have to have a mail stop. You have to have somebody to receive mail.
Right.
Even a statutory entity is required to have a registered agent. So that's not the point. That what we have with the natural law trust is the ability to stay out of that statutory process, but we have the ability to define what we want in a very clear way and make it happen, make it manifest.
Are there any benefits in creating the name of your trust in your personal name? I see some other natural law trust YouTubers speaking that it is easier to get a bank account open with this strategy. Not sure if this is correct information.
It's partial. It depends on the bank. It does nothing to do with what the name is. We have clients that use a family name. We have clients that use an abstract name. It's your choice. It's where, when you sit with your banker, who are you? And what do you want to present to the banker? The name doesn't mean anything.
Right. I've never heard that anyone had any easier time if their name is in the title of the trust.
No,
It's the trust structure or the nature of the entity that they either
right.
understand and cooperate with, or they don't understand. And
Right. Yes, the banker has to read the document and he's not looking at the name, he's looking at what clauses, as we talked about earlier, are there that make him feel safe that this trust document is worthy and we should do business with this person.
right. Carrie is asking, does the natural law trust work in Mexico?
Well, we have clients basically Central, South America, North America, Canada, Africa, Europe, UK, not India yet, but Asia. So it's working somewhere.
And we're going to expand to other planets pretty soon.
That's right. The moon is looking right at us.
Yeah, it's the law that is drawn up on under is not under any country's jurisdiction. So that's why we say it's international.
Right.
It just could be that banks might give you a harder time in some countries because they don't understand it.
Right. Some countries don't recognize trust law. So there is that. And so what we do, we're implementing ways to work around that. It might be a simple statutory structure within that country to allow a foothold in the bank, and then the trust that the client has would be the owner of that statutory process. So we can do it that way too. There's ways around it, and we're working on a referral, looking at possibility of having a bank where you can do online and not have to show up. It's a US bank. You won't have to show up. You can do it all online, and you present to them our trust document and they
Right.
will open the account. So we're working on that. And that's not just, that's not a brokerage account. This is any bank. We're being able to walk into a bank and they're saying, sure, come on in. That the working with the trust will be so as commonplace as working with your own person. And the reason that the banks don't like to work with trusts is because because it's inviolable. They can't go after it, and it, when you own it, they can go and get you, but if the trust owns it, it's much more safe and secure. Okay,
Which means if the bank turns you down, they've probably done you a favor, you know?
right.
If they're too voracious, you know, and if they're willing to cooperate, they're probably a better bank and better branch or, you know, department.
Right, they understand. If they accept it, they understand what our contract law trust does.
Yeah.
I've gotten away from calling it a common law trust. I just call it a contract law. It's just a private personal contract
Right.
in the form of a trust.
Verena is asking, from this point onwards, the trustee himself can lawfully contribute further assets into the trust, but a second trustee is required if the first trustee is also a beneficiary.
Correct. So I don't advocate that you be a trustee and a beneficiary mostly. You can be a trustee and then the beneficiaries are your family, your children, or projects or whatever. If you want to be a beneficiary, a trustee and a beneficiary, then you need to be a beneficiary of less than 50%. And I don't like to do that. Why don't you come in as a funder and get TCU units and have your funding for the assets that you put in trust be separate from units of beneficial interest? So we're starting to define our clauses and parameters and paradigms a little more frequently too. So this is all coming together. It's just being more refined. It doesn't mean that it's anything more or what we have is less. Just we're including a little bit more involved with it so that the clause is more definitive.
That's smart thinking.
That's a good note to close on.
Well, you want to handle the rest of the questions?
Oh, yeah, no, just joke. Oh, sorry, it's just a joke.
Okay.
Yes, or question. Get me out of here. I'm sinking. I want to answer more questions.
So Verena's continuing. I haven't understood this option yet, how to word it that I can be the first trustee and the beneficiary. Well, you just addressed that. Okay. Then I can also mention other beneficiaries, such as my three sons, and any other partner could also be named as beneficiary afterwards. Would this also work as I think she means to say beneficiary, right, for the partner?
As long as there's a non-related second co-trustee, I would say that's okay. But if your family are all the beneficiaries, then you need to have unrelated second co-trustee.
Yeah, at least one beneficiary has to be unrelated
Right, well, one trustee.
and one trustee. Yeah.
Okay.
She's saying, can I also set up an association later as a beneficiary and be its board of directors or its president?
Sure, any entity that you want can be a beneficiary of your trust. Just has to be defined. So you can't say, I want to feed all the dogs in the world. It's better to say, I want to feed my dog Jerry.
And then add to it later, maybe.
Well, it needs to be defined. You don't want the beneficiary to be nebulous.
Right. Has to be defined.
Right.
She says, when filling in the beneficiaries, the status can be changed by me as trustee at any time, the names and shares.
Yes.
Okay. That would really be ideal because the future brings new people into the living environment, and this flexibility should be maintained so that the trust can always name the correct beneficiaries at the time of the trustee's death. There may be disputes that only come to light later, and there may be new people whose expertise and loyalty make them particularly suitable as beneficiaries later on.
Yeah, that's excellent. We just talked about that a couple of minutes ago. everybody in the trust will change over time. Rockefeller, Kennedy's, the Rothschilds, those trusts have been around 200 years. So yes, change, everything changes, and that's okay. The uniqueness about the trust document is that it has a foundation, and however many levels or additions you want to add to it, it totally compensates for that and allows for that expansion. You just keep adding addendums and minutes and maybe break out a few trusts here and there to house a particular project or to house another asset. So it's diversification, it's separation, but basically the main trust will always be the beneficiary of everything underneath it. And the difference between that and between you and your family, if you did it without any entities, is that you'd be stopped every generation along the way for probate and for all kinds of stuff because you're a fiction within the government. And so if you have everything in trust and it's set up properly, there's never a lapse in time. If you die, beneficiaries keep on receiving, the trustees die, you have a successor trustee. So it's a unique system. It works extremely well. And you'd be very well served to have a number of NLT trusts.
And therein lies the wisdom in reminding everyone that good records are very important. It's good to keep them on paper in a 3-ring binder, and as well as in the computer.
Right.
So each month or whenever there's a transaction or a change, add a minute, add another page, add any new documents into the 3-ring binder and online in your computer.
Yep.
Yeah.
The paper trail is critical. And it defines your ability to make it all work. So just be diligent, do a good job at what you do, and don't worry about anything because the trust can handle whatever situation is happening.
Yeah. Verite is asking, who is available for legal clarification in Germany should there be any disputes with the trustee?
The first thing would be to do, what is it? You go to a person in between, an administrator, or what they call it,
Mediator?
a mediator. And so you go there first. Doesn't matter what country you're in, it doesn't matter where you are, you have a right to sue or be sued with the trust. So if there's a fault in your contract with somebody in your country, no matter where it is, then you can bring suit and the trust will honor that. And the trustees need to make sure that they're capable of actually delivering on that and either defend it themselves or to be able to hire the right people to do that.
And a reminder is that no court on the planet has any authority to invalidate the trust, but specific transactions can be given limited jurisdiction for litigation.
Right. It's the fault that it's the hurt. If you foul somebody, they get a foul shot. It doesn't invalidate the game.
Right.
So the same thing is that if there's something that's wrong, there's an issue, then the issue gets fixed, but it doesn't invalidate the trust by any means at all.
Right. Charlie's asking, you mentioned the first 15 pages being solid. Does this mean we can state in this section elements that can last into perpetuity, obviously upon 21 to 25-year renewals? For example, the original grantor making sure they have their original trust writing stays regardless of how many take over?
You don't need to do that, I don't think, because the first 15 pages is again, it's your foundation, and everything beyond that is always going to be subject to minutes and changes. It's a natural course of events, and it should be any trustee going into this vision should make themselves very aware of what it takes to be a competent trustee. and we have a great bibliography. And, you know, there's myself and Laurel she's just coming right up to speed, and there's always people to fill in. So please just always ask questions. And there's a great there's a document Weiss. It's in my bibliography. I think it's posted on the web. Isn't our bibliography posted on the BIC website, Tanzan?
What's on the BIC website?
Isn't my bibliography on the website?
We haven't put it on the website, but we've posted it in newsletters and it's available upon request.
Okay. There's just if you're going to step into this role and you really want to be a competent trustee, then you need to get a few particular books. And if you have questions about which ones are best, then you can write to me or you can write to BIC and we'll get you that information. And then at some point when Laurel's ready anyway, so whether she wants to give her information out or not is up to her. And if she wants to do that here on this call, we can do that.
Charlie says, thank you. I have your bibliography and is reading through. But you know, Randall, you are like, I mean, light years beyond most people in your knowledge and the study. I think for most people, it's like buying a car. The trust is like a car. You want to go someplace, you get in the car and you drive it.
Right.
You don't necessarily have to have studied all the mechanic manuals about how every piston works and every, spark plug and carburetor and everything,
Right.
all the details of the mechanics. That's what that bibliography does,
Well, yes, but if at some point, if you're going to be your trustee, then really it's imperative as a fiduciary responsibility to learn at least the basics. I'm not saying you have to learn what I've done at all.
Yeah.
The Weiss document is 50 pages long. It will give you enough information to be competent enough to do what you need to do on a daily basis. And if you need more than that, then Laurel and myself are available.
Do you think it would be a good idea to just include that for every trust client?
I think I put a bibliography in whenever I send a trust document, I send a bibliography.
Okay.
That's one of my attachments.
Okay. Then we don't need to post it on the website. It's just there for
Okay.
clients. Yeah.
Yeah. And if the client hasn't done it yet, but they've connected with you and they have my information, then they can write to me and get the bibliography if they want it first. It's not a problem.
Right. Verena asks, I also ask, who can provide assistance in Germany if the tax office refuses to generate this other tax number, which ensures that it is now a trust? What is this number called in technical jargon?
Well, I don't know what they call it in Germany. Over here, it's called an employment identification number. In Canada, it's a revenue number. In Australia, it's a Australian tax number. So I don't know. It's just what you have to go to your tax people and say, please, Mr. Bill, don't hurt me.
Well, actually, the bank could
Or
have,
the bank.
yeah, the bank will say, this is the number you're going to need to open a bank account.
Right.
Here's how you apply for it.
Okay. Well, the bank won't know, but the bank will say that we need a number and they'll leave it up to you. So they may offer advice. Laurel, I know she came back the other day. She said that one bank didn't have a notary and another bank did. And then, so it just depends on the bank and who's in there and your relationship with the banker as well.
Yeah, but they'll tell you what kind of number you need. And it's pretty easy to find out where to get it. I've never heard of anyone being denied getting the identification number anywhere in the world. Have you?
No, never heard of that.
Yeah, so it's not going to be a problem.
Well, the bank will tell you what they need. You said it right in the beginning, Tanzan.
Luke says, you guys are awesome. Thank you so much for the sound wisdom and patience with my questions. Thank you, Luke.
Touche, brother.
Archer says, would you talk a little about the BIIP? I'm reading the book from the website. Want to use it to fund a business I am working on. Thanks. Well, Archer, that's my area of consultation, and that's not the topic of today's meeting, but I'm more than happy to assist you privately. You can click on contact us on the website, and your email will go to Peter, and he'll put you in touch with me, and then we can talk. Reggie says, can you put a vehicle in this trust and cancel your regular insurance and registration for private use?
Oh, please, Mr. Bill, don't torture me. No vehicles in a, never put a liability in with an asset. Okay,
Unless,
so a liability is something that can hurt somebody, and an asset is something that makes your life better. So a liability, a car, any vehicle, anything that moves is a potential liability. A broken fence on your back deck is a liability. So be conscious of taking care of any potential liabilities, and so that your assets are protected. So never put a car in a trust with an asset. That's
with
bottom.
other assets, right?
And
But
that your car is,
again,
unless your car is a $500,000 Ferrari, it's not an asset, it's a liability. So
in which case
any
you
liability.
you get a separate trust for it all by itself.
Well, if it's a Ferrari, for sure. If
Yeah.
it's a Ford, you know, have a beer.
Elizabeth says, what is the tax treatment of an NLT?
There isn't any.
Does that answer your question, Elizabeth? There is no tax treatment.
It's an exception to the rule. It's a private contract between
Yeah.
two people.
She says, are NLTs protected from lawsuits?
No, not if they hurt somebody. So what the trust does is it takes your assets, separates it out. So if there is an injury or a fault happens, that it won't affect the asset. That's the bottom line. That's what you're looking for.
Right. Are NLTs considered foreign per the Weiss manual?
Well, of course, that's why it's an exception to the rule. Because it's foreign. It's foreign to the US government because it's an unalienable contract.
It's foreign to any government.
It's foreign to the fictional government. That's
Right.
It's not foreign to the state, the republic of the state, or the people of the state, because it can sue and be sued, but it is foreign to the government unless you enter a contract with the government. If you are filing a 1040 and you have filed a 1041 for a trust, then you might be in the system and the government might come and question you if you don't file. So please make sure that if you're coming into with a natural law trust, that you make sure all your paperwork for all your other stuff is handled. Make sure that you know your status, you know who you are. You can stand in front of a court and say, I am this person, I'm not the fiction. And BIC and myself and Laurel can support that. And other people in BIC, Charlie, and everybody involved will all support the vision it's showing on the screen right now, which is to be free and floaty.
And Luke is saying, if I get this trust and I get the trading account and the name of the trust, and when I make the profit in the trading account for the trust, is this not a taxable event, correct?
Not as far as I can see. Depends what the trust is doing. It depends. I can't answer that on the air because I don't know what the process is, what you're doing with the trust. So that would be a personal thing that after you buy the trust, that then we can delve into that. But in a sense, it's not up to me or Tanzan. It's up to a trust attorney to decide and how you want to do that. Now, we can supply you with particular attorneys that are conscious and just, but that's all we can do. Typically, again, it goes back to the default. If the trust hurts somebody, then it needs to stand up. If it's been in the tax system and it doesn't pay taxes, then you got to watch out. You got to not perjure yourself. So just be aware of the paper trail and what you're doing with the vision of the trust. And there's my hometown.
Yeah. Well, Luke and everyone, we're not licensed tax advisors or legal advisors, so we cannot give advice. But I can at least, Randall, I can just give my own experience.
Sure.
I've been using these since 1993 and never had a single problem. In fact, Randall and I don't know anyone anywhere who's ever had their trust penetrated, their natural law trust penetrated, or made liable by any tax agency unless the trustee voluntarily submits to it,
Correct.
starts filing returns. So
Right.
that's why Randall said it's up to you. But if you choose to not file, we've never heard of that being a problem for anyone. There
Yep.
is no intrinsic requirement for these entities to file or pay.
Right. Because the whole tax system of the US government is a voluntary process, and we just choose not to volunteer.
And that's the case in the United States, but even other countries where it's not so voluntary, still the trust is not under those tax requirements because
Correct.
it's non-statutory.
Right.
So now in the United States, I'll add that for newcomers, if you are new to the natural law trust, when you apply for your EIN, which is for banking purposes only, not for filing tax returns, and that's the ID number the bank requires for you to open the account, there will come a letter in PDF form on the computer, on the internet, at the IRS website, saying you must file Form 1041 on this trust. So, do you have to comply with that? And I am here to tell you, no, you do not. Why? Because they are assuming it is a statutory entity because they don't know anything about it. They don't know who you are. They don't know what kind of, and they will never know. They will never have a copy of the trust. And they don't choose to acknowledge that it exists. Their hierarchy chooses to keep that quiet. So there are people who create these systems assume it's a statutory entity subject to their requirements. So you must file Form 1041. But if you know, okay, here's the saying that applies to this. The only rights you have are the rights you know you have. The only rights you have are the rights you know you have.
Mhm.
So if you know that this is a non-statutory entity and you have the right to not comply with that requirement, then in effect, you have the right. You're able to enjoy its benefit. So I don't know how many thousands of us around the world have these kinds of trusts, but we've never heard of anyone having a problem with the tax man.
Again, I think in the clarity came earlier, we talked about it. Again, it's a trust can sue or be sued. And so you just have to remember that you want to operate on the highest level of justice and conscience that you can. And then you're fine. And keep a paper trail and you're fine. Your estate will go on for hundreds of years.
Blair says, to be clear, it does not matter what country you are. The natural law trust is universal. It creates the acronym once, own nothing, control everything. Would this be a simple understanding of the structure of the NLT entity?
I like that.
Mm-hmm. That was it Rockefeller who said that? Own nothing.
I think, yeah, it's they all.
Yeah, you're
Anyway,
basically removing the ownership liability while retaining control.
absolutely. I mean, look at Chappaquiddick.
Mm-hmm. The Ken-
Anyway, it's too numerous to go on, and it's okay because we know that if you follow what the wealthy have done and you follow us with BIC and the Natural Law Trust, you'll be fine. And that Natural Law Trust is a document that will stand by you for as long as you want.
Okay, Luke says, is this a 501c3 trust where any profits the trust makes is not taxable?
No, it's not a 501c3.
So, Luke, have you read the ebook? That would answer that for you. You need to read the ebook. Yeah, 501c3 is a tax exempt organization authorized by the IRS, which means they can also remove that authorization anytime they
Correct.
want. It's
Yep.
statutory, whereas our entity is non-statutory. We don't say it's exempt, it's an exception, which is far more powerful because they cannot remove an exception.
Because it's not in there. Gee, Mr. Bill, I can't find it.
And he says, can you have the trust pay the trustees' living expenses?
Yes. If that's their job, if their job is to take care of the house and take care of the business and to make sure that the stability stays within the realm of this estate, then absolutely has to be taken care of.
That means it's according to what you put into your trust as your purpose
Correct.
and instructions. And should you mention the minutes, the housing resolution and spiritual resolution?
There's an attachment that goes with every one. One is right there. I mean, it's not only in the trust, but we have an attachment. One is it caters to any housing needs, and two is it caters to any spiritual needs.
Yeah.
So there you go. I mean, that's right there. It's the basis of power of the trustee is to make sure that whatever needs to be done within the trust to keep it happy gets to be done.
If you are the trustee, then those minutes authorize the trust to compensate you for your trustee services.
Right. And it's in the power and administrative duties of the trustee. So it's in the trust document, those first 10, 15, 11 pages.
Luke says, I really enjoy listening to you both. Randall, you are a world of knowledge. I could listen for hours. Thank you, Luke. Mahalo.
You bet. Anytime.
Charlie says, am I right in presuming, like in other situations, that the use of notaries can be replaced by multiple witness signatures? And
Two witnesses.
his question goes on, but I'll stop there.
Two witnesses work.
Two witnesses.
Unrelated.
One related?
Two witnesses unrelated.
Unrelated. Yeah, that's in common law. Yeah.
Yep.
And also, as we are most likely using trusts for business, signatures are best used, not autographs, as sovereigns would use. And would there ever be a need for or benefit for autographing instead, so long as you don't mind revealing your personal identity?
You can do whatever you want. I don't feel a need for any of that stuff, but if people have a need for that to be, we can set up in the document the name is spelled accordingly. So it's just a preference. I don't see a need for it.
Right. And certain pages need to be notarized.
Well, only in the abstract, there's only 3 documents. One is a memorandum because we want to now notary the grantor, and then we notarize the trust certification and the memorandum trust certification. And then the other notary is if you have a foreign currency, you want to notarize that, but that does not go to the bank. So only 2 things of notary need to go to the bank. One is a certification, which is necessary, that needs to be done. And the other memorandum gives the bank an idea of what the trust is going to be doing, what the intent.
Well, you know, things have changed recently, Randall, and does that satisfy the banks, or do they want the grantor resignation notarized as well?
No, because it doesn't matter because that the relinquishment of control by the grantor would be in the trust document in that, you know, what you're going to leave at the trust at the bank anyway. You're going to give the bank a copy. You can give a copy of the whole trust document to the bank except for the minutes.
Right.
If the banker wants to see the appointments and acceptances, then show it to them. And
You
so
remember I told you that I applied at a credit union for a trust that had my mother as the grantor, and she's deceased, and
right.
it wasn't notarized, so they wouldn't open the account.
Yeah, see, so that's why if you notarize it now, then it's done. And so and then it can go on. And also sometimes if you have a successor trustee, then before anything happens to you, you might want to have the successor go to the bank and get on the signature card so that if something does happen to you, there's no delay in the ability for the successor to come in and start writing checks.
Right.
So successor to the bank when you go to open up the account, if they're available. If they're not, doesn't matter. But just be aware of that if the trustee is right there with you, the grantor can notarize their signature, and the trustee that's going to be successor trustee, if they're already on the bank statement, then it's just easier facilitation.
Maybe the assignment of the grantor and the resignation of the grantor might be good to notarize as well.
No, I don't, I think that the fact is, you notarize a memorandum, which includes the grantor and the two trustees and the trust certification, and that's all you really need. It's
Okay,
all,
that satisfies the banks.
yep.
Okay. Things keep changing. That's why I'm asking, because everybody knows I've been around these for years, but banks have gotten
Well, and some notaries still want to, they want to see the whole document. And I say, no, your job is not to see the document. Your job to know the fact that there's a document sitting right here. You don't have a right to see it. You just have, your job is to notarize my signature,
that's
period.
right.
That's it. That's your job.
That's
You're,
right.
you're my employee. You're the notary. You're public. You do it for me.
And that teaches everyone that, you as a signatory trustee on these documents puts you in command, and you've got to show that authority to
Yes.
systemites.
Yes.
Yeah.
And
Martha has,
most notaries are like that, but I think Laurel had an issue with a notary the other day, so just be aware that those three signatures are crucial for a notary, and that facilitates the easiness into the banking system, then just do it.
Martha has an interesting question. I've recently received notices from LLC managers and banks requiring the names, addresses, etc. of all members. If the member is a trust, they want the names of the beneficiaries. Apparently, there is a new Fed regulation requiring this with extremely stringent penalties. How would the NLT handle this?
Well, the NLT is not a statutory process. Didn't we deal with this with a client this week, Townsend?
Yeah,
I
but
think,
she's talking about an LLC of which the trust is a member. So the statutory requirements apply to the LLC.
fine, so the LLC, the owners are recorded. I did that in Hawaii. We had an LLC here, and me and Marissa were 2-3% owners each, and the trust was 95% owner, and there was no problem whatsoever.
And they didn't ask for the names of the beneficiaries?
Well, yes, they asked for the owners. An LLC would be the owners, not the beneficiaries. They
I
did
mean,
not ask the beneficiaries of the trust because they're not the owners.
yeah, but she's saying that since the trust is a member of the LLC, they're asking for the beneficiaries of the trust.
Well, if that's what they require, then give it to them, but you might want to check on other states that have more ease and more openness to setting you up and not having to deal with that, like Nevada or Dakotas or Idaho.
I wonder if,
That's really unusual that they would, how can they ask for the beneficiaries of the trust? And the trust is just the owner. That's not their business. That's very,
because with most statutory trust, which this is not, but they may think it is, they're trained that way, they think,
well, yes, I understand.
they think they're responsible to the beneficiaries.
Right.
So
But I would do it. I would just say, I'm sorry, this is a private trust and beneficiary is not available and, or so either you deal with it and let them have some information to get the account open or find another bank.
what about producing an affidavit saying that this trust is trustee controlled and that uh, you have no obligation to the beneficiaries?
Right, that's what the memorandum is. And
Right.
Laurel has helped me refine that a little bit, but basically, yeah, that memorandum covers all the aspects of the fluidity of what we have with the NLT.
And
So
point number 7 in the trust certification minute, point number 7 shows that too, that
right.
the bank
So
has,
you have the 11 pages in the beginning that gave the stability. Then you have your trust certification and the memorandum, and it covers all aspects of the trust, and you're done.
yeah. I think, Mata, that might take care of it. I think if you have further questions, you can write to us.
Right. Yes, please.
Verena saying, what could be a total error to do as a trustee? I think she's asking like, what mistakes could you make that you should avoid?
Shoot the messenger. No, no mistakes. I mean, if you actually, mistakes are okay because mistakes are how we learn. So if just be in consciousness and be in justice, and then you got it covered.
Yeah, you can make minor mistakes, no big deal. They could
Well, we all do.
Yeah.
We all do.
As long as you're not harming anyone, there's probably no major mistake.
Right. Do no harm, honor your contract, and do no harm. The two premise of common law.
Right. So Verena's saying, have you heard about this CLC, commonlawcourt.com? I recently got this green passport there wherein I claim the fiction name as my birthright back.
Okay. Nope, not going there.
I wonder if that's enforceable.
I don't know. That's
Well, let us know your
different.
experience with it, Verena.
It's a different story. That has nothing to do with the trust.
Right. Okay, Charlie says, also, if, as I do, wish to create a group of expanding charities and foundations for a variety of purposes, would it be wise to have an umbrella trust that oversees them all whilst maintaining some distance from each?
Yes, absolutely. And that's what we've been doing with the concept of you have your main trust and then you have fingers out for every project that you might want to do. I mean, in the beginning, just run your events in the first trust. And if it gets to be expensive and you have two assets that have substantial value, then create the second trust and separate them out. Just start small and work up into larger amounts. I'm sure that's what Rockefeller and the Rothschilds did. Well, first trust.
That is called estate engineering, Charlie, and Randall is an expert at it. So when it comes to that, he'll know how to link one trust to another properly and advise on that privately when the time
Right.
comes.
Absolutely.
Okay, let's see what we have more here. Verena, did I understand it right that Randall said that also a nonprofit trust agreement is a statutory trust within government restrictions
The 501,
in the United States? Yeah.
it depends. I mean, the charity, you can do 508, you can do 501 charities, which is a government sanctioned charity. You can do a 508, which is a non-government funded ministry but that's separate from a trust, and you don't want to combine those. If you have a ministry, that's fine. 501 is something given to you by the government that can be taken away. A 508 is a natural, unalienable right to have your religious beliefs honored. And the natural law trust is the right to contract with anybody that you want.
Thank you. Well, to keep it simple, Verena, what Randall delivers to you is a non-statutory trust. As long as you don't convert it and change it to a statutory entity, it will remain non-statutory, and you can do anything with it that any statutory entity can do. It can be a charity, it can be a foundation, it can receive grants, it can make grants, it can do everything that any statutory entity can do. You don't need to convert it to a statutory entity.
Right. Exactly. Like you said, Townsend, we've been, I think White Light Unlimited was created just in the late 80s, mid 80s to late 80s. And then it just went on from there.
And
It's
that
still,
white light goes
still
on
happening.
expanding.
White Light Unlimited is still happening.
It's still unlimited.
It's still unlimited.
Michael's asking, looking to put my father's house in this trust before he dies. I have 3 other siblings. When the time comes to sell the house after my father dies and distribute the proceeds to myself and my siblings, would this be a taxable event for each of us?
If you assign the house to the trust and then the trust sells the house and then the trust distributes to the beneficiaries, then the beneficiaries would be liable for their income that they receive from the trust, the beneficial interest that they receive from the trust, if they are filing a 1040 return. If the trust decides to keep it and buy another house, there would be no taxable event. So you can sell it and be responsible for the taxes on it, or you can leave it in the trust and have the trust create another investment portfolio, and then the beneficial interest might be coming out at a slower rate and the tax liability would be less and less and less. So rather than take it as a lump sum, you might consider having the trust keep the investment within the trust, and then it can come out to the beneficiaries at a different rate.
Yeah. So to keep it simple, Michael, what stays within the trust is never taxable. What goes outside the trust then depends on whoever receives the distributions, what their status is. But a good way to go is for each of the beneficiaries to get their own natural law trust. And then the distributions could be made to their trusts, which could then be non-taxable.
Right. So it's a choice again, and you have to think about what is the status? The siblings all want to stay together, or do they want to have the estate and go their separate ways? So that's just a choice that the trustees, somebody has to make at some point.
Steve is asking, once the creator passes, can there be changes or addendums to the indenture?
Absolutely. Well, not to the addendum per se, but whatever additions or subtractions need to be done to facilitate the betterment of the trust organization, then yes.
And
Our intent we have within the trust document is pretty broad and encompass pretty much of everything, so that all of that flexibility can be encompassed within the document.
yeah, most changes you would want to make only in the minutes. If you're considering a change in the indenture, you'd want to consult with Randall first.
Right.
And then he says, if the creator identifies a protector for the trust and subsequently the protector dies, who assigns the new protector if needed?
Well, if the grantor is gone and it's just the trustees, then you don't need a protector, because the protector is there only because the grantor has chosen trustees and he's not quite sure that he wants to have the ability to hire and fire a trustee if he doesn't feel it's appropriate. But basically, if you're your own trustee or you're having trustees that you're familiar with, there's no need for a protector. It's in there. I don't think I think one client maybe 10 years ago used that just to replace, but that was it. It's not a needed function, particularly if you know your trustees.
Right. Verena saying, what is LOC? I think
Limited liability company.
yeah, I think Verena, it was LLC. I think that's the word you're referring to, limited liability company. Right. Lynn is saying, I did not get the memorandum of irrevocable trust minute notarized as it wasn't indicated on the document. Bank did not ask for it to be when opening up the checking account.
It's fine. That we never had it notarized before. And it just because we had a client, they went to the bank and the banker said, well, we have the notary, we need to notarize for the grantor. And so I just included that. That's why I included the memorandum as a notarization paper, because the grantor signature would be on that aspect. And then there's no need to have that grantor signature or a new grantor ever again. It's done. It's complete.
Okay. Blair is saying, how long does it take to set up the NLT for a family cottage with 3 generations to be a part of it?
Couple of days. It's not, that's not an issue. You just have to, the issue would be, I would need the deed to the property and who the trustees and who the beneficiaries are. That's it.
Yeah.
It's up to you to decide. In fact, last 2 weeks ago, I sent a trust off where I left Schedule C, which was the beneficiaries was all blank because he wasn't sure what they wanted to do. And so I said, okay, well, all you have to do is either in the computer input it, it's in a Word program, or write it in with pencil and paper on the document itself. It's not an issue. And if we don't have computers and typewriters, the early trust work was all done on pen and paper. So there's no reason that all your minutes, a lot of your stuff can just be notes on a daily basis in a minute book. It doesn't have to be typed in or signed, just a paper trail, a good paper trail.
And
And
that,
keep all your emails for your trust work. Keep them
yeah.
in a file.
Charlie's saying, do you think it would be a good idea to have farmers under the NLT to effect removal from government contracts so they can tear up their contracts and return to direct selling to the public?
Well, yeah, that's what Laurel's been doing with the PMA. A client of ours, Rich Blackstock, taught Laurel, he are working together. She's mentoring with him. And that's the whole essence of what a private membership organization is. So if any questions about that, Laurel would be the one to talk to.
Archer says, is the art of passing the buck on your bibliography, Randall? I read both of them. The answer is yes, Archer. Elizabeth says, is the NLT revocable or irrevocable? It's irrevocable, Elizabeth, and with good reason.
Yes.
What is the rough cost of an NLT with you? That's a sliding scale. It depends on your net worth. So write to us, either go to your affiliate or place a ticket with contact us on the website and we can take care of that for you. Laurel is asking if you would like her to talk about PMAs a little bit.
Sure, if you like.
Laurel, if you want to raise your hand so people can see you, I can put you on the air. I'm going to ask you to unmute.
Am I visible?
Yep.
There you are.
Okay.
Yes.
All right. Wonderful. Yes, thank you. This is all just so exciting. Understanding our rights for liberty, pursuit of happiness. It's all written in the Constitution, which with all of my learning in the last years about all of this, it's just really understanding our rights. Then we understand the foundation that our house is built upon, brick by brick. And that's when the courts cannot touch us. And that's why Randall's NLT is so well written. All the bricks are in the foundation. And so therefore, there is something, a private membership association that can take it even further. I created a ministry and I have the private membership association as like the front door. So everything walks through that place. That takes everything into the private. My ministry, my two trusts. Yes, two trusts. And so it's all an ecosystem unto itself. And I just wanted to state that understanding our true rights, and I'm in the middle of and almost completed writing up something that we can put on the BIC website that will be like Cliff Note version of all of that I've gleaned from these two amazing gentlemen and so much more, and doing it myself and hearing what the banks say. And so that's really all I wanted to say about the PMAs. It just takes it more into the private, and it creates that front door that takes everything into the private, whether you have an LLC attached to your NLTs or however many NLTs or ministries, etc. And I'm available to assist in that, as well as being a trustee and a grantor.
So, Laurel, you are writing up a PMA for BIC, and you're also going to be writing them up for anyone who wants one. We'll be posting that information on the BIC website when it's ready, right?
Right.
And the benefit thereby is, especially if you're a business or an organization providing things to the public that maybe certain vested interests wouldn't like you be giving out, by putting your organization under a PMA, especially a non-statutory one, you can honestly say, we're not giving this to the public. We're giving it to members only.
And I just walked into a federal credit union right here on our small little island, and they said yes to my PMA bank account and recognized it as a ministry, so to speak, for them to understand it. But no worries, no problem.
And does it have to be a ministry, or does it need to sound spiritual or religious, or could it just be any kind of organization?
ABC, and we don't want to use the word organization. That alerts the statutory guys. We are
Okay.
an association of members.
Association. Okay.
That's a really good distinction to have and hold. So, and whatever members do with each other after that, whether it's providing a product or a service for the betterment of humanity or for feeding your dog, whatever it is you want to come up with, it's all in the private, very well laid out.
And
In the
like the NLT, will this be transcending geographic jurisdictions and be equally applicable everywhere in the world?
Yes. Again, it's just a contract.
Under contract law, which is world.
Yeah, and it fits so perfectly with the NLT because, again, it's another contract entered into on a free will basis by the people that want to be involved and hear what we have to say. It's a perfect dynamic to add to the NLT train.
Would one own the other? Like, would the NLT own the PMA?
Well,
With the what?
Nothing to own, is there, Laurel?
No, you're just becoming a member.
Right.
You might pay a fee. It might be free.
So what's the relationship between the NLT and the PMA?
It's a contract. It's well, okay, my hit on it, and Laurel can add to it, is that if you have a trust and you have a number of people in your social structure or business structure, then if you have a PMA, then that gives more shielding or seclusion, or and as a like a front door, as Laurel said, where people can come in and interact with your NLT on a private basis. Is that true, Laurel?
It just makes it all private, personal, member to member. There's no government reaching in at all. Not possible.
How would it be worded? I mean, would there be like a minute added to the trust saying this particular business is now a PMA? I mean, how would you word that? I'm just curious I'm still trying to picture how the relationship would be with the NLT.
Yes, as a matter of fact, I'm dialing that in as we speak. That is my one last piece that I'm getting really clear on. So I'll hold off on an answer to that so that I'm really clear and don't waste your time.
Okay. So like Randall said, it's some sort of a contract, but I'm just wanting to picture what form the relationship takes between the two.
Well, if you think about a church, just as an example, everybody in that congregation is a member, and that's all. Everything is done, and it's all in the private.
Okay.
So
Especially if it's not a 501. If it's a 501, you're limited in what you can say. But if you're a PMA or a 508, then you have the right to say whatever you like because you're not under a government contract.
Right.
Correct, Laurel?
yes. Just another really good, smart level of privacy.
Oh.
Well, the questions and answers will be accumulating on that topic, and maybe one of these days we'll do a Zoom just about that. Yeah. Okay. Anything else?
It works for me. It's been a really good session.
Thank you. Thank you. Mahalo. Me, Louis. So May 15th, July 17th, 2 months from now, we'll have the next one. It's about the middle of the month. So everyone, thank you for your contributions. Thank you for your compliments. Thank you for your questions and wonderful comments. And Randall and Laurel, thank you for what you've had to say. The door to a new time is opening for you.
Thank all of you people for showing up. I really appreciate it.
This will be posted on YouTube as usual, so you'll get to see it there.
Okay.
All the best, everyone.
Thank you very much.
Peace.